the consent agenda?
Yeah, I was just wondering if we should have somebody sworn in about that.
No, we typically do not. We make the motion and we pass or reject the consent agenda.
Okay, then I will entertain a motion regarding items 1 through 31.
I move that we accept this consent agenda items 1 through 31.
Do I have a second?
Second.
All those in favor say aye.
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 All opposed? Okay, next we have the ones that nobody responded to on the consent agenda. Those are items 32 through 40. Do I have a motion on items 32 through 40?
I make a motion, we accept the items 32 through 40.
Okay, do I have a second?
Second.
All those in favor say aye.
Aye.
All opposed? Okay, next we have ones that were denied due to timeliness. Amanda, I guess I need to get you sworn in on this.
So, Mr. Smith, actually today, Anita McCoy will be presenting these. So if you will swear her in.
Okay, all right. Anita, will you, let's see. Need to get you to raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name and position with the county, please.
Anita McCoy, Division Manager on Land Records and GIS.
Okay, all right, what do you have for us on these?
The very first one that I have is American Dance Festival. The owner meets all qualifications. The exemption type is under GS 105-278.7, charitable educational. And the tax year is for year 2022. The date the application was received was 4/4/2022. The application due date was 1/31/2022. The reason why they were late, according to the taxpayer, they found out that they were eligible to apply through their CPA after their annual audit was completed. This is the first time that the taxpayer has filed for an exemption. My recommendation is that this is a nonprofit organization. They meet all qualifications. The fees that they charge for these classes are low and represent less than 5% of the organization's annual income. I recommend that the board, the taxpayer is requesting that the board approve and grant the exemption as timely.
Okay, any questions from the board? Then I'll entertain a motion regarding item 41.
I move that we accept item 41 as timely.
Do I have a second?
Second.
All those in favor say aye.
Aye.
All opposed? All right, let's move on to the next ones, please.
And Mr. Smith, I'm actually going to do number 42 through 47.
Okay. All right, now let me get you sworn in. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name and position with the county, please.
Amanda Markle, Deputy Assessor over the listing land records GIS divisions.
Okay, so what do you have for us on these?
Okay, so these are 2021 applications for CIP Real Property LLC. It's several properties. They submitted their application in November. For some reason, it went to a junk folder. So we did not actually know it until they called us in earlier this year and said, why haven't you responded to our application? So at this point in time, they meet all the qualifications for their exemption. We are requesting approval to accept their late application.
So you said the late application was not really their fault.
It was not their fault. They submitted it in November, and we did get verification and the proof that it was submitted in November.
Okay, all right, then I will entertain a motion on items 42 through 47.
I move that we accept items 42 through 47 as timely.
Do I have a second?
Second.
All those in favor say aye.
Aye.
All opposed? Okay. All right, well, let's move on to number 48 and 49. And I think that's back to you, Ms. McCoy. Is that correct?
Yes, sir.
All right, what do you got on these two?
These are three parcels, parcel 169331, parcel 105-801, and parcel 105-803, and that's Ellaby Creek Watershed Association. This is for tax year 2022. The date of application, the application was received was 3/24/2022. The application due date was 1/31/2022. The reason for being late was the taxpayer completed the 2021 application instead of the 2022 application. The appellant was under the impression that the application was due by January 31st of the year following closings. That's why they completed the 2021 application instead of the 2022 application. My recommendation, this is a nonprofit organization, and they on their form for why they were late, they did provide justification. So I request that the taxpayer be granted approval from the board to grant application is timely.
Okay. Any questions from the board? Any discussion? Then I'll entertain a motion on items 48 and 49.
I make a motion, we accept the application is timely.
Do I have a second?
Second.
All in favor, say aye.
Aye.
Okay, all right, then let's move on. All right, to number 50. This was denied for timeliness and for qualifications. Can you tell us a little bit more about that, Ms. McCoy?
Yes, sir. This is parcel 188-074. The address is 501 Orange Factory Road. This is the owner is Discovery Charter School Foundation, Inc. And they're seeking an exemption under GS 105-275-46 charter school property, educational exemption. According to the form that they completed, the organization was aware that charter schools were exempted from the North Carolina property tax by North Carolina statute. The land was purchased on March the 5th of 2021, and construction development began. Final construction and development was August of 2021. My recommendation is to uphold county recommendation to deny the application. And the reason why is 3 reasons. 1, Discovery Charter School Foundation, Inc. did not own the property on January 1 of 2021. 2, property did not meet use requirement. Property was not used as a charter school on January 1 of 2021. Number 3, application was received after 12/31 of 2021. And for those reasons, I recommend that the board deny the application.
So they have to, excuse me, they have to have owned the property January 1st in order
Yes,
to
sir.
apply for this. Is that correct?
Yes, and the property has to be used as a charter school as of January 1, and it was not. They
Then
purchased the land on March the 5th of 2021, and construction began, and construction finished by August of 2021.
okay, all right. Mr. Forsyth, I assume you're here for this item.
Yes, I am. Can you hear me?
Okay, and let me get you sworn in, please, sir. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name and your association with the school, please.
My name is Carl Forsyth, and I am the board chair of the Discovery Charter School Foundation.
Okay. You've heard the county's position. What's your response?
My response would be that the Discovery Charter School Foundation owns the property, the building, and the fixed assets, and that we are volunteers and citizens and lay persons. The timeline of the case is accurate. We actually began construction on our building in September of 2020. We did acquire the property on March 2021, and we actually acquired the CO for the property on 2021. We were late paying the 2021 tax bill because the tax bill was mislaid, and I did not receive it. When I did receive it, we did pay the bill, and the amount of $2,484.59 was paid. And then at that time, we did make an application to request tax exemption for 2021. We did make an application. We did fill out the form and did check the box under which charter school property, GS 105-27546. The reason for the denial by Durham County was on the letter that they sent to me was based on educational exemption. I was confused about the difference between the box we checked on the application, which indicated charter school property, and the denial, which was educational exemption. Based on my knowledge, and I'm just a layperson, I'm not anywhere an expert, we do qualify, and I think it was the General Assembly's intent that charter school property would be tax exempt.
I think the problem, sir, is that you had to have owned the property on January 1st of 2021. And that's what the general statutes say. I mean, otherwise, I think you're exempt, and you could be exempt from 2022 onward. It's just because you didn't own the property on 2021, the law states that you cannot be exempt for that year.
Okay. Okay, understood.
Okay.
Another question that I do have is that also on the application for tax exemption, there is a box that we did not check that indicated educational purposes, institutional. If we reapplied and checked that box under that general statute, my question would be to the county, would we qualify for 2021? And we're talking about 2021 because we have qualified for 2022.
Well, yeah, it's again, you didn't own the property on January 1st. So that's really the limiting factor, and that's the problem. And no matter what you check on there, you're not going to really make a difference. Okay.
Okay.
All right. I will entertain a motion regarding item, what's this? Off the chart here. Hold on a second. This is item 50.
I move that we uphold the county position and then deny this time.
Okay. Do I have a second?
Second.
All those in favor say aye.
Aye.
Okay. All right, sir. Thank you. Okay, let's move on to item number 51. And this is back to you, Amanda. Is that correct?
Yes, sir. I'm not sure if Mr. or Miss Nguyen is going to be here or not.
Okay. They're not in the waiting room or anything, are they, Sonia?
Here.
Oh, okay. All right.
All right, perfect.
Well, go ahead.
Right.
Yep. Amanda, please proceed.
Okay. So this is an application for the disabled veteran exclusion for tax year 2022. We received it earlier this year. The application was denied because the disabled veteran on the application was not part of the ownership of record as of January 1 of 2022. The veteran was added in March of 2022 as part of the ownership.
Okay. All right, Ms. Nguyen, are you available?
Yes, I sure am.
Can you turn your video on?
Yes. Hey there.
Hello.
Hey.
Get you sworn in, please. If you raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth to help you God?
I do.
And are you comfortable using this video format?
Yes, my husband's here.
Okay. All right. Okay. You've heard what the county has to say.
Correct.
So what's your response?
We were planning on getting married in 2020. And because of the pandemic and so forth, we were not able to do so and had to push it out. Well, because of my husband's age and whatnot, and the fact that we were going to be married, we wanted to be sure that our property was named so accordingly. Well, we did our own paperwork with the advice of probably not an attorney. And when we transferred the property, it went completely to me and not adding me. Well, we did not realize that that was in error until we found out about the disabled vet program for this and submitted the paperwork. And when they sent it back and said that his name was not on, we were like, oh, wow. So he was added back. We have the deed and it's recorded in the county. And so we submitted the paperwork. We got the denial. So we wanted to appeal. I guess the only smart word I have for that is ignorance, to plead ignorance. But we are married now. We're married in 2021. So we're just asking for an appeal for that based on the fact that we just simply created an error and asked for the board's leniency and forgiveness.
So the property was in his name, and instead of adding you, they transferred it totally to you.
Yes.
And then when you found out about it, you transferred it back to both of you.
Yes. And, you know, obviously we were married, et cetera. So, yeah.
Okay. Any questions from the board? Any discussion? I mean, what do you
the year that they're asking for, January of 21, only her name was on the deed?
This is a request for 22. So January 1 of 22,
Okay.
only her name was on the property.
Okay.
And about how long was your name not on his name not on the deed? When was the transfer made just to you?
It was made after we received the denial because we didn't know that there was an issue.
No, but when was your name supposed to be added to it? When, you know, you say it was that, when was the error made is my question.
The error was made in 2020.
Okay.
And we were married in April of 2021. Never knew there was an issue until we found out from someone that we were eligible for this and filed the paperwork and got the refusal. And we were like, oh my gosh, we made a mistake.
Okay. Any other discussion from the board? I mean, technically they don't meet the requirements.
I know we don't. That's why we're asking for leniency.
So what do you all think? You think we should stick with the letter of the law on this one or be lenient?
I mean, look, based on the case before us, we went by the rules.
And consistency, unfortunately.
Yeah.
Okay. All right. Then I will entertain a motion regarding this item.
I make a motion, we uphold the county's recommendation.
So I have a second.
Second.
All those in favor say aye.
Aye.
All opposed? Okay, sorry. That's just kind of the way it goes.
All right. Well, thank you for your consideration.
Okay, thank
So
you.
it will be in effect for 2023. Is that correct? Now that our names are both on the deed and it is filed with the county?
You'll have to submit a 2023 application. We'll have those later this year.
Okay. All right. Very good.
All right, thank you.
Thank you.
All right, let's move on to the next items. And this is back to you, Amanda, also, correct?
Yes.
And it looks like there are two different kinds here. Do we need to talk about these separately or together?
Separately, please.
Okay, all right.
Okay. And I want to make sure we should also have on here Brian Wardell from the county attorney's office. And I believe we also have some representatives from the church that are supposed to be here.
Okay.
Just to make sure.
I believe they're represented by counsel. I don't see the name of the attorney here, but I do believe that they are represented by counsel.
And we are running early, so I didn't want to get started.
Right. Maybe we should wait. let's take a break until 10:45 and give them a chance to get on. Okay, see you back then.
Sonia, you're sharing your screen.
Can somebody come off of mute and just let me sound check so I know I can hear you all okay?
Testing 1, 2, 3.
Yeah, we can hear you quite well. Thank you.
We'll wait just a minute for one more board member to come back.
Sorry, I didn't realize I was not being viewed.
That's all right.
We can see you now.
Okay.
Unfortunately for you.
I'd say the same. Do we have any more than the allocated 10 minutes?
If we need to run over, as long as it's not a whole lot.
Okay.
Jeanette, we can see you, but you can't see us. Is that what you're saying? You're muted, so I can't hear you either.
Jeanette, are you able to unmute yourself? Oh, no. The lights just went out on us. I just replaced that light bulb too.
So small screen can't get large. Like, Jeanette, can you unmute so we can hear you?
If you press your space bar, hold it down, that should unmute you temporarily.
Is there any ability, whoever is the host of the meeting, can they unmute Jeanette?
You have to ask to unmute, so I think she would still have to click on something.
I got it.
Okay, good. So you got, is your screen okay too, Jeanette?
No.
Small screen, huh?
All I see is the chat.
No.
Hold on a minute. Let's see. Oh, I don't know.
And does anybody know where Tony is?
Move window to left side of screen.
No, not sure what happened to Tony. Maybe she lost connection.
Yeah. Like I say, I'm not getting my normal screen. I can see David and I can.
Hey, Jeanette, can you, in the top right corner, do you see like a little grid that says view?
I've got a minimize, and I've got like four bars, and I click on one. They're not really doing anything.
Okay.
I've got a Mac is my problem. Okay. See, I can see everybody there, but I guess it's okay. I mean, okay. If y'all can see me, I can see you now.
Do we need to wait for the other member of the board?
I'm going to give her I'll give her another minute or two, then we're going to go ahead and go.
Yeah.
Is this, is it being recorded in a way that if there is a board member who wants to see it, that they would be able to?
Well,
So
Yes,
she
we
would
are.
have to be,
We're being recorded.
yeah, it's recorded, but she would have to be present and be able to respond and hear any questions to comply with the remote meeting statute. So
But we don't have a quorum right now.
we have
we do have a quorum. I think we do have a quorum. We just don't have the full complement of the board.
Well, I think we'll go ahead and proceed. She's 5 minutes late. So, Amanda, if you'll, I guess you'll proceed with this. We need to swear people in. She's already been sworn in previously, so that's why I'm not swearing her in.
Who's
And,
been sworn in previously? I'm sorry.
She was sworn in previously. So are you with the Shepherd's House? Is that correct, ma'am?
Yes, I'm Jamie Paulin. I represent Shepherd's House. I have two individuals here in the office, and then Mr. Charles, is it Missouri? He's on the Zoom call. He would have been present in my office, but he's got COVID. So, but I really only anticipate calling one witness. I want to try to keep it brief. I was going to give a brief opening statement myself and then call one witness. So he's the one that actually needs to be sworn in.
Okay, well, we'll start with the county and let her sort of lay the groundwork, and then we'll come back to you, all right?
Oh, okay, yes.
Okay.
So we're going to start with the 2021 applications. So items number 52 through 57 on the agenda. So the 2021 applications is what we're referring to at this time, okay?
Okay.
So these are applications for religious exemption for tax year 2021 for the 6 parcels listed. The application was received December the 8th of 2021. The due date was January 31st of 2021. However, we are requesting that the board accept these as timely. The taxpayer did submit their reason for late application, which included, it was a very, very long list of why their application was late, but we are requesting that the board accept the 2021 applications as timely.
Okay. All right. Miss Paul Lynn, is that Lynn? How do you say your name?
I say Miss Paulin.
Paulin. Okay. All right. Let me get you sworn in first of all. If you will raise your right hand.
Do you want all of us here to be sworn in case any of us, or just
Yes.
me?
Let's do you all at once. So,
And they're going to come. Can you see all of us?
I can't see Mr. Is it Mazzara?
He's on Zoom.
I don't see his video. Okay, I see him now.
All right.
Okay. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
I do.
Okay. All right. Well, we're going to start with item number 2021. Oh, and are you comfortable using this Zoom format?
Yes, we're prepared for it. Thank you.
And what is you're an attorney. What is the status of the other people that are going to be testifying?
So I have here the Reverend of the church, and then the chairperson.
Okay.
The chairperson of the church council.
Okay. All right. The first one we just heard was the 2021 appeal. And as you heard from the county, we routinely grant these as timely. So I'd like not to really go into any discussion right now because it's not controversial. And then we'll move into the ones that appear to be more controversial, if that's all right with you.
Yes, agreed. So, I mean, of course, we would like for it to be accepted as timely.
Okay, then I will entertain a motion for items 52 through 57.
I make a motion, we accept those as timely.
Do I have a second? David, we can't hear you.
Second.
Okay, all those in favor say aye.
Aye.
Okay, it passes. All right, let's move on to items 58 through 63, and we'll go back to you, Ms. Markle.
And from the county's perspective, I do also want to bring it to your attention that Brian Wardell is on here as well. I'm not sure if you need to get him sworn in before we get started on the next group.
Okay, Mark, let's go ahead. Mr. Wardell, we get you.
So as counsel, I don't need to be sworn in. I'm not.
Yeah, I know, but
you can go ahead.
All right, go ahead.
Okay, so items number 58 through 63, these include the 2019 and 2020 applications for religious exemption for 6 different properties. These applications were denied because they were not submitted within the calendar year on which the property taxes were levied. The applications were received December the 8th of 2021. Although they were for tax years 2019 and 2020.
So did they pay their taxes in 2019 and 2020?
No. The 2019 and 2020 taxes are still outstanding.
Okay. All right. Ms. Pauline, I'm sorry. Let's hear from you now, please.
Well, I had an opening statement, but I think given how we've proceeded that I could mostly probably skip some of it, but I just wanted to give some context that the church was owned by the Methodist Church Corridor District prior to 2018. In 2018, there was a deed from the Corridor District as like the overall kind of governance of the church to a group of trustees of this particular congregation. It was that deed transfer that seems to have triggered this particular issue, but the management of the church has never really changed. So when this deed transfer happened from the Corridor District to, I think it's 5 or 6 individuals that are named as trustees of Shepherd's House Church, the church actually did reach out to the Corridor District and ask them what they needed to file. And so what I'd like to have is for the chairman to explain, I'm going to have him move over and sit here so you can see him, but I'm going to have him explain what happened. I'll lead him through some testimony and I'll have him explain what happened. So we're going to switch seats. Thank you. And so can you introduce yourself for the board members?
My name is Esau Mavindidze. I'm the current lay leader and chairperson of the church council.
When the deed transfer occurred in 2018, were you aware that there was going to be any requirement for the church to file an exemption for property taxes?
Not immediately, but the chairperson of the district trustees wrote to us to say that that was a requirement, and he gave us an example of how they've been filing.
So this person provided you with a tax exemption form to provide to the Durham Tax Department?
That's right.
And were you personally involved in completing that form and then sending it to the Durham Tax Department?
Yes, me and Mr. Mazzarura, who is the secretary.
And Mr. Mazzura, just for clarification, he's the other individual from the church that's on the Zoom. And so do you recall when this form was sent to the Durham Tax Department?
I would like to say it's around 2019, but I'm not very specific. But we did file that form, and we received a notification from the tax office that we had filed a wrong form.
It was a tax exemption form, but you were told it was the wrong version?
Yes, the form that we filed was the example that we got from the Corridor District trustees. That's the form they've always filed, and they told us to file that form.
And so at that point, did you receive a response from the Durham Tax Department regarding that form?
Yes, we did. And they said that it was the wrong form, and also that we had delayed filing. So they required 2 things: that we correct that form, and also that we give a reason for delay.
And did you do those things?
Yes, we did.
And then what happened?
Well, this whole thing coincided with the pandemic, And so the tax office closed, and our church closed as well. And so the communication that came thereafter was very difficult.
And did you yourself send emails to the tax department?
Yes.
Did you also make telephone calls yourself?
I made telephone calls. I talked to somebody who confirmed that the office was closed. And the individual I talked to gave me the personal cell phone number for their supervisor and also the email address. And I proceeded to call, but I never got answered. But I also wrote email.
And so at some point, did you continue to try to contact them throughout the pandemic, or did you at some point kind of give up?
Well, we would proceed each time we received a bill. Then we would start all over again to, to try to communicate with them.
And then at some point, did you become aware that the church had decided to retain legal counsel over this issue?
Yes.
And do you remember when that was?
Can you help my memory, Rev?
I think it was a year ago when we
Can you hear him? Just want to make sure that you can hear him. He is sworn in as well. Go ahead. Yeah, introduce yourself.
This is Reverend Dr. John Gumbo. I'm the senior pastor of Shepherd House United Methodist Church. Just to answer the question about when did we file, it was 2019 when we received the title deeds. We did file the letter which we were given, the forms. Then after that, I think it was 2020, we started receiving bills which says we owe taxes. Then every time we received that, we corresponded back with phone calls, writing emails through the committee, which we also have those emails. And in 2021, I think that's when we heard that this church was going to be on sale. And we thought by then we need to find an attorney to represent us, because we had tried everything we can and it seems to be just failing.
So because I am sworn, I will just, as a additional back piece, I personally, after I was retained, I tried emailing, I tried telephone calls, and then I personally went to the Durham tax office and received the proper version of the form. And I did at that point file for all 3 years. But that filing is not the one that both gentlemen are referring to. They had at least made an effort to file an exemption form in 2019 and 2020, but it apparently was not the correct version of the form. And so I'll just wrap up because I don't want to take too much time. Just wrap up by saying that what we're asking the Board of Equalization and Review to do is to basically deem that those filings, because the church made an effort to file an exemption, and while it might have been the wrong form, these are lay people. The tax office was on notice that this church was claiming a tax exemption, even though they may not have used the right form. And while they were trying to correct the issue with the form, that's when the pandemic occurred. And so I don't think there's any disagreement on the side of the county or the tax department that this church is a church. They don't generate business there. It is a congregation of individuals that they can't afford, even if you take out the 2021 taxes, you're still talking probably over $50,000. They don't have the ability to pay that. And it's inequitable to be taxing this church when all churches similar to this church are exempted based on the fact that these lay people filed an incorrect version of the form. They now have the correct version. That's what I filed. And so we're just asking the board to apply that exemption to 2019 and 2020. Thank you.
Ms. Markle, what happened? It sounds like they repeatedly tried to get in touch with the tax office. Do you have any information on what happened, why they couldn't get through, and if they did in fact try to get in touch?
I can personally say I have called the church multiple times personally. Like I can't even say staff has returned calls. I have personally called the church. So I've personally spoken with multiple people at the church throughout the years. Yeah.
I believe it sounds like they tried to correct it, but we're not able to contact people to correct it with.
Mr. Wardell has his hand up.
Okay.
Yeah, this is a few things. One, has the appellant provided copies of the emails with the dates and times that they attempted to email the tax department? That would be the first question I would have. And then on the second note is, even if the board were to be sympathetic with the plight of these lay persons, there is no there's no statutory authority for the board at this point to grant any relief to the church, because the statute clearly says, and that's 105-282.1, that if you file for an exemption after the calendar year has expired, then there's no authority for the Board of Equalization and Review to provide any relief. So I understand that there may have been some miscommunication, but at my last check, there were more than 60,000 calls taken during the pandemic, and other churches and other tax-exempt organizations managed to file their exempt notices and were in fact granted exemptions. So statutorily, there's no basis for the board to even consider these appeals. Other than for 2021, you can consider it timely because it was filed before the end of the year. But the other two, 2019 and 2020, as a matter of law, you don't have the authority to grant what they're asking for.
Does anybody have that authority?
No.
So, sir, I'm going to say that you've just heard testimony from my clients under oath that says that they did in fact file an exemption form in 2019 and 2020. That's exactly the entire point of me having these individuals here explaining that. So if they had filed nothing, then I would agree with the assertion that there's no statutory basis. But what we are saying is that there was an attempt to file an exemption, and that was filed in 2019 and in 2020, and that there was an issue with the version of the form, and that therefore the Board of Equalization and Review actually does have jurisdiction to go ahead and not retroactively, but to apply the exemptions for those years.
So unfortunately, that is not correct. And my interpretation of the statute is that you have until the 31st to provide good cause. Now that would potentially be the basis for good cause for a late filing. But after the expiration of the year, there is no
Sir, what I'm saying is that they filed it in 2019 for 2019 and 2020 for 2020. I'm not talking about the form that I filed for them in 2021. I really am having a hard time understanding why you're continuing to talk as though none of this just transpired. My clients have said that they sent that form in 2019 and in 2020, but that it was the incorrect version of the form. They were trying to correct that when the tax department shut down.
There's no evidence of that.
There is evidence. My clients just testified under oath, sir. That is evidence. The fact that your tax department I have received nothing, by the way, from anybody, despite making a public records request that shows any communications between the tax department and my client, although the individual who just spoke was able to testify that she had spoken with multiple people at the church. The sworn testimony, in fact, is evidence.
So the sworn testimony, as I recall it, was that they received the tax notice and
no, sir, that was not the testimony. And if Mr. I'm so sorry. I don't. If he wants to, he needs to. I would like to
finish.
No, but you are incorrect.
One at a time, please. One at a time. Let Mr. Wardell finish first, please.
The sworn testimony.
Testifying as an attorney.
And wait just a minute. Just wait a minute. He's giving legal advice. So, all right. Proceed.
The testimony presented was that they received the notice. They were aware of the need for filing. They received information from their organization about the process for filing, but they never actually filed the correct form to get the exemption.
That
is the testimony and the evidence in the case.
That is not the testimony. You will explain again. Go ahead. And
ma'am, please let him finish. You'll have your chance.
If in fact there was good cause, that good cause would have been sufficient under the statute to allow the particular exemption to be considered timely. But since it is beyond the end of the year, the end of the taxable year, there's no statutory basis at this point, because whether they tried to do it, whether they were misinformed, it doesn't matter, because they didn't do it. And they didn't ask for it to be considered late, but accepted within the statutory period allowed by 105-282.1.
All right, let's hear from her response. All right, please, ma'am.
I'm going to have the chairman again repeat exactly what he said previously. So can you once again explain?
Yes.
And the Reverend as well. How did you come about filing the tax exempt form prior to 2021?
Yes. So like I said, we received notification from the Corridor District trustees that this was a requirement, and they gave us copies of how they used to file. And we just duplicated their filing format and the forms that they used and filed. And we have proof that we filed because we got a response from the tax office to the effect that we had completed the wrong form and that there was a delay. And so they needed two things, us to correct the form that we had filed, and also to provide a reason for the delay. So like I said, further correspondence was hindered by the closure of that tax office.
And then Reverend can speak to when those were actually sent. So when was the first version of that form that you received from the Corridor District, and what year was that sent to the tax department?
That was 2019 when we received the title deeds. We were also given the forms to file, and we did file the forms. And after we filed the forms, we received an email saying that that was the wrong filing form, which we had filed. And we asked for the proper forms for us to file. And that was 2019. And we went ahead and filed. And we received 2020, again, that we owe taxes. And we again write back phone calls, not only our chairperson, also one of the members of the trustees, which is Mrs. Walker. She called She sent messages. I personally myself, I did call, and we have trace of all those communications. So if evidence is needed that we filed in 2019, yes, we have it. These are emails. This is not just talking. 2020, we have evidence of corresponding with the tax department. Up to 2021, we have all those evidence that we're trying to make the issue fixed. So we have done everything we can. We might have done it in a way which is not the right forms and what we are not professionals in taxing, but we did what it takes for us to correspond with our tax department.
Let me ask you, in 2019, when you were told that you had the wrong form, did you get the proper form and send that in?
Yes, we did.
So if that went in 2019 or early 2020, why wasn't that counted as an?
They were still sending the forms that the corresponding back to us that there was something wrong. And when we tried to talk to anybody, there was no answer on the phone calls. So for us to get someone to help us to really do what they wanted, it was just, you just find a bill, then you try to correspond with them about the bill, no one will answer you. Then the next time you find another bill and you still try to see how you can communicate, but communication was down.
Yeah, so they gave us like a number for the form that we were supposed to complete. And this is done online. We went online and downloaded that form. And then when we completed, they said it was wrong again. So we needed to talk to somebody to tell us what was wrong, regardless of, we'd completed the form that they had asked us to. And this is where we were having problem getting somebody to correct what they were saying is wrong.
Well, Mr. Wardell, if they provide this information, these emails, will that make a difference, or have they still missed the deadline, so there's nothing we can do about it?
So if in fact there was a filing and they requested it to be considered a late filing for good cause, then there would be something that could be done. There's no evidence that they presented of any emails. If in fact they have the emails, then this is the time to present it to the board. That is documentary evidence, and that could be considered by the board. But even so, without that, there's certainly no avenue for this board to grant relief, because you're outside of the calendar year that the taxes were due. So the board has really no authority to grant them the exemption at this point. The statute is clear and straightforward. Now, the opportunity would have been between January and December. If they were having problems, then they could have come before the Board of Equalization and Review, and they could have presented their emails, and they could have said, well, we've been trying to do this, but this is the reason why we can't get it done. The Board of Equalization and Review was hearing cases 2019, 2020, 2021. And just like everyone else who had a problem and they wanted to appeal, they made their appeals, and the board ruled on those.
Well, if they were to supply that evidence, would it make a difference in what we could do?
No, not from a legal standpoint. It would not at this point, no.
Even if they brought forth those emails they're talking about, that we still couldn't do anything.
Correct.
I'll just let you know, board chair, that I did provide those emails. So in the material that's been sent, there is evidence of the email back from the tax department saying that the improper form was filed. That's why I produced it. They don't have a copy of what they filed because they printed it and sent it. But what they do have is the correspondence showing that the tax department received a form from them and attempt to apply that exemption, and that it was the improper form. And so I'll just say, again, from a legal standpoint, I disagree with the fact that the board does not have the power. If nothing had been filed and there was no evidence whatsoever, I would not disagree with Attorney Wardell. But But in this circumstance, we can show, and that was the point of producing that the tax department did receive a form. It was the wrong form. And then during the process of trying to correct that is when the tax department shut down. And so there is a bit of mystery to me as to why we have all of these people wanting to, essentially penalize this church for attempting to correct an issue during just when the world was completely turned upside down.
And yeah, I think we understand your point. But Mr. Wardell, if we were to grant this exemption, I guess in your opinion, we would be exceeding our authority. But what would happen? I mean, would the county be able to say this is exempt? And I guess the county could sue us or whatever. I mean, we'd be breaking the law according to your opinion. But what happens if we say, okay, we're going to grant the exemption based on what the other attorney has to say?
So since you don't have the statutory authority to act, then you would be acting outside the jurisdiction of your authority. When you act outside the jurisdiction of your authority, you open yourself up potentially, and the commission is up to personal liability. So that is the issue, and that is the problem, because everyone on the board acts as a surrogate for the county commissioners themselves. And you cannot abate, forgive, forego any just tax without statutory authority to do so. And so if you just go ahead and do it, then you would potentially be personally liable if someone else who was denied an exemption, and they say it was because they were corresponding with the tax office and the tax office was closed, da 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 da. So you have to be consistent in how you apply the rules and the law. And the law is straightforward. You got essentially 11 months to cure the problem. And if you don't cure the problem within those 11 months, then the Board of Equalization and Review does not have the authority to compromise that tax. And so that is the potential. Now, will that happen? Nobody knows, but you would be acting outside the confines of the law if you did that.
All right. Well, I'm going to cut off discussion from the outside on this and talk to the board some. I'm really frustrated with this because I would like to give them some relief, but based on legal counsel, it doesn't seem like we can. I don't know what the rest of you all think. I mean, it seems like they did everything they could to try to get this taken care of, but legally, we are being told that there's nothing we can do. I mean, what's your all's take on this?
So they filed the incorrect forms, and so we don't do we. It's kind of frustrating because if they file the incorrect form, that should be emails. We should be able to see that. The board should be able to work with them. And why bring it before us if it was outside of jurisdiction anyway to act on it? I don't understand. Why we're hearing cases that, why bring a case to us if it's not within our jurisdiction to act on it? Why are we sitting here listening to wasting all this time to hear something that we can't do anything about?
Well, I think the other side says we can do something about it. She says since they filed the forms that we have the authority to do it, but the county is saying no, you don't. So that's why we're hearing it, because they feel like they've got the right for us to do this, even though they filed them in error. They still filed them.
Right. Well, I mean, do we not have copies? Even, I guess, if this happened 2 years in a row, and I don't understand how it didn't get corrected for 2020 if 2019 wasn't done correctly. How did it happen for 2 years in a row that the wrong form was filed and they didn't get the right form? I don't understand that. And I agree with David that if it's out of our jurisdiction, my only question is, if it's out of our jurisdiction, I don't feel comfortable being told that this was out of our jurisdiction to act on. And, you know, I'm not an attorney, and we're listening to our county attorney here tell us that. Can they appeal it to the state?
Can they, Mr. Ward? They can?
Yes, they can appeal. They can appeal it to the state. This is a prerequisite to them being able to do that.
But if we say we're not making a decision because we've been told by you as our county attorney, this is out of our jurisdiction, so it's nothing. We don't make a decision, they can still appeal to the state.
Well, you would have to make a decision. The decision would be to deny the exemption, and then they would appeal that to the State Property Tax Commission.
But you're telling, well, I see what you're saying, that based on the information, we should deny it based on the legal advice of you. We should deny this.
Based on the fact that the board does not have
the legal
to grant them the relief that they're seeking. Yes.
All right.
Okay.
Tony, do you want to weigh in?
Well, I need to recuse myself from this, unfortunately.
Oh, okay. All right. Well, I think we have to deny it, and that will give them something to appeal. If we don't make a decision, they can't appeal it.
Right.
So anyway, I will entertain a motion regarding this item.
That is, thanks.
Jeanette, David, one of you needs to make a motion.
I'll make a motion, we deny the appeal based on not having the legal jurisdiction.
David, you second?
Second.
All right, then it's denied. And again, I feel very frustrated and very sympathetic to you all, and I wish there was something we could do. And hopefully when you appeal this to the Property Tax Commission, they'll straighten it out.
All right, we appreciate your time.
Okay, thank you.
Thank you.
You know, it's amazing, Dave, that a wrong form has been filed in 2 years. You can't get a right form refiled. And
well, they kept trying to contact the tax department, and you know, the pandemic was going on. So, you know, I just wish there was something we could do, but there's not. Okay, well, let's move on where we're running a little late. Okay, this is item number 64, Melissa Frisbee. I don't know that I've met you.
Hi, no.
Hello.
How you doing?
Let's get you sworn in first. You raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name and position with the county.
I'm Melissa Frisbee, personal property supervisor.
And this is a property's SCM Metal Products. Do we have somebody from them present?
Yes, this is Diana Kennedy.
Ms. Kennedy, is that you?
Yes.
Okay. All right, we'll hear from the county first and come back to you. Okay, Ms. Frisbee, what do you have for us on this case?
So the taxpayers are requesting abatement of the late list penalties for the tax year of 2022. And pretty much they submitted their personal property listing through our online business portal. They filled out, they were granted an extension request, but they missed the deadline due to personnel turnover. And they were requesting an abatement of the penalty. So I was able to verify that they did actually have an approved extension. However, we did not receive their online submission until May 25th of 2022, and they had until April 18th of 2022 to file on time. So as of right now, we are recommending that the total penalties remain on the tax receipts per the general statute 105-312H.
And when was the original filing time, filing deadline?
The original was April 18th.
No, that was the extension. When was the original one? Like January 31st?
Oh, January 31st would have been the original.
Yeah. Right, and so they already got one extension, and then they missed the extension timeline, correct?
Right.
Okay, all right, Ms. Kennedy, I need to get you sworn in, please, if you'll raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name and position with this company, please.
I am Diana Kennedy. I'm the Senior Director of Tax and Treasury for Chimera International. I'm located at the plant SCM Metal Products here in Durham.
So you are an employee of the plant?
I am.
Okay. Are you comfortable using this video format for your appeal?
Yes.
Okay, all right, you've heard the staff. What's your testimony?
I apologize for not uploading any additional documents. I just received the notice of the hearing yesterday as I was out of the office for the last week. But my testimony is our county manager, Teresa Baskovich, was responsible for our books and records for our fixed asset listing here at our plant, as well as the lease schedule. We finalized our outside third-party audit on March 23rd. I had the property tax listing, which I went over with her at that time, since she handles all of our fixed asset listing and is the supplier of the information. I was scheduled to be out of the office the week of April 11th, so I walked her through how to do the online filing, as well as how to upload. We went over the detailed listing of information that she would need. We had gone over the books and records from our year-end audit and identified we only had additions, as well as to attach the normal lease schedule to it. While on vacation, without advance warning to me, Teresa was let go. The announcement was, or the notification was done on April 14th, and the notification came to me on April 15th. When I returned to the office, we had a lot of discussions about what responsibilities and things that needed to be done. We oversaw our payables as well as our accounting management, and part of my function is treasury. I did not become aware that the filing had not been completed until after the extended due date of April 18th. Since I needed to gather the information and had discovered this late in May, I gathered the information that we needed and filed it as soon as possible and requested the abatement. I'd like to say we do have a record of paying timely, as well as a large taxpayer here in Durham, and have a history of filing on time as well as payment on time.
So have they paid, Ms. Frisbee, have they paid the actual taxes? Or no, I guess it's just a listing, so they wouldn't have paid yet, correct?
It's the listing.
The bills haven't been
just the listing
generated yet.
The payment, our historical filing would generate a notice in September, and we pay that in December.
All right, any questions from the board? Any discussion? I understand there was turmoil, but it seems like if you already had an extension once, that you should have been able to meet the deadline. That's kind of my thought about this. You know, what do you all think?
Yeah, that's a company problem, not our problem.
The county did what it was supposed to do, and it granted them an extension.
Right. Yeah.
Right.
So.
And we did file it within 30 days. Past, and I apologize for that.
Okay. Any further?
Well in advance of the property bills that would get issued in September.
And any further discussion from the board? And I will entertain a motion regarding this item.
I make a motion we uphold the county's position.
Do I have a second?
Second.
Second.
All those in favor say aye. Aye. We think that the penalty is appropriate, ma'am. So thank you for coming.
Can I get a sense of how much that will be?
Ms. Frisbee?
So the estimated tax amount is going to be $22,815.98.
Okay. All right, let's move on to the next one. And Ms. Frisbee, you're on this one also. Do we have somebody here from Cree?
Hey there, my name is Jessica Pearson. I'm the Global Tax Director at Cree, now currently known as Wolfspeed, but formerly known as Cree.
Okay, so you are an employee of Cree or Wolfspeed?
Yes, that is correct.
All right, let's get you sworn in. If you raise your right hand, please. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth to help you God?
I do.
And are you okay with this video appeal?
Yes.
Okay. All right, well, let's hear from the county first. Ms. Frisbee.
Good morning, Mr. Smith. This is Andrea Williams. I'm actually going to handle this one, so I need to get sworn in.
Okay, all right. Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Okay, what do you have for us on this one?
CRE is asking for an appeal of the penalty assessed for an amended filing that was received in our office in February of 2022. They noticed that there was an error with the software that they were using or the system that they were using, and which resulted in an underreporting of assets. So once they discovered the error, they submitted the amended return. The amended return created a under assessment, so we had to create a supplemental bill. The total amount billed was $104,620.70. $9,510.97 is the penalty. Staff recommends the total penalties remain on the tax receipts according to North Carolina General Statute 105-317.1H.
So they came forward and found the mistake and brought it to your attention.
Yes.
Okay. All right. Okay. Ms. Pearson?
Hey guys, so from our perspective, we noticed the mistake when the bills were issued, as they did not reconcile to our internal records of what we expected our property tax bill to be. We hired DMA to do our property tax returns for us. They have a valid power of attorney to act on our behalf for our property tax returns. And so as soon as the bills were issued and we noticed there was a discrepancy in the assessed value, we reported that to Ms. Melissa Frisbee, as noted, and filed the amended return timely to increase the assessed value and pay the additional tax that was due.
Okay. Well, I don't know about the rest of you. I'm of two minds. First of all, this is a large corporation and they should probably know better. On the other hand, they were good citizens and came forward. So, I would be inclined maybe to give them some relief. I don't know what the rest of you all think.
I'm feeling you on that day. I agree with you.
So I think in the past we've done like 50% reduction.
Right.
Yes.
Would that be something you all would be okay with?
I would.
We're good people and brought it forward. So I'll entertain a motion regarding this item.
I move that we reduce the fine by 50% or the penalty.
Second.
Second.
All those in favor say aye.
Aye.
Okay. All right. Thank you for coming, Ms. Pearson.
Thank you all, I appreciate it.
Okay, moving on to errands. Is this Ms. Frisbee or Ms. Williams on this one?
I am on this one, Mr. Smith.
Okay. All right. So is there anybody here from errands?
I previously reached out to the attorney on record, but did not get a response.
And this penalty amount is $409,000. Is that correct?
So this is a value appeal. They submitted their 2020 listing and did not list all the assets. So we discovered them for a total of $409,382.
Okay, so that's not the penalty. That's the amount of the asset.
Correct.
Okay. All right. Okay. What have you got for us then? What else can you share with us?
Just that they underlisted. In doing a normal process of listing, we discovered that they did not list the assets that should have still been in their possession from the previous year. So we assessed them the $409,382, and we requested that that value remain on the tax receipts per North Carolina General Statute 105-312.
Well, I'm looking here, and actually we're 2 minutes early, so maybe we should wait just a minute, just in case. We don't want to get in trouble. Starling, is there anything else we need to talk about for 2 minutes while we're waiting for them?
I don't have anything in particular, but I was going to discuss as our next meeting date of July the 20th.
Okay, let's do that while we got a minute. Yeah, that works for me.
I think that works for me too.
I'm good.
Yes, I'm good for that.
Yeah.
Okay. Well, then we will schedule our next meeting for July 20th. That's a Wednesday at 10 a.m.
And I guess we're going to Zoom until further notice. Is that correct?
We haven't heard anything about not Zooming.
Well, are you all Zooming most of your meetings? Is the county doing that?
Yes, sir.
Okay.
Yes, sir. And I think the way things seem to be heading right now, I think it would be wise, unless the state told us otherwise, to continue to meet through Zoom, virtually. I was trying to think of the word virtually. To meet virtually until we're told otherwise. And Brian has not said that we have to start meeting in person. So he hasn't said anything, and he was here today. So,
but yeah,
but I haven't heard anything at all. I haven't received any mail or anything concerning not doing virtual hearings.
Well, I do like the Zoom. The only thing I don't like is being able to see you all in person. But I've met most of you. So, you know, I think if we had like a new board member or something, we would definitely should meet, you know, in person. But I know all you guys now. I don't think it's as necessary. And down the road, I really like this format because when, you know, if we've got 15 minutes to kill, we can do something, you know, all of us.
Yes.
Instead of just staring at each other for the time. So.
And we have not had any real complaints. And I mean, when I say that, I mean, everybody has been really for the meeting virtually because the companies like it because they don't have to spend as much money to file an appeal and have it heard. And we had a few taxpayers who were, as they say, were limited in how they could handle working with the electronics and the virtualness of this process. But fortunately, we got all of them taken care of, and we don't have any more pending live hearings. And so we've taken care of all that had wanted to have a live hearing. They're done.
Yeah, well, that's good. But it may be good, you know, down the road to at least meet once a year in person. But,
yeah.
Cross
And,
that.
and if you all choose to, we could, starting next year, you know, just for the sake of ahead planning, we could say maybe meet on the initial meeting of the year, live and open, and then carry through that. And that would give us the opportunity to commune as a group and get things lined up for future hearings and stuff. So if that being the case, we'll look forward to, we'll work towards setting up our initial meeting in 23.
Yeah, let's do that, but have that be live, you know, in person instead of Zoom. Okay.
Okay.
All right. Well, it is 11:43. So, let's see. Well, you're not Miss Markle. You're at Amanda's desk.
I'm having some technical difficulties at my computer.
Oh, okay. All right. Well, then let's proceed here, Ms. Williams. With is there anybody here from Aaron's? Okay, seeing none, then let us proceed with this appeal.
Okay.
There is a J.H. Smith here that was not in here earlier.
Okay. Mr. Smith, can you tell us which case you're here for?
Oh, okay. That was one of us. Okay, sorry about that.
Okay.
All right.
Okay. All right, Ms. Williams, let's proceed with Aaron's.
So this is for Aaron's 2020 value. They are appealing the value that we discovered of $409,382. In the processing of their listing, we noticed that they did not carry forward equipment from the previous year. So we discovered it and assessed them for that amount. So we recommend that the total value of $409,382 remain on the tax receipts per North Carolina General Statute 105.312.
How much is their penalty? Do you have that readily available?
The penalty, sorry, at a different computer now. Give me just a second. The penalty would be a little over approximately about $4,700.
Okay. All right. Any discussion from the board? Any questions?
But Mr. Smith, they're appealing value, not penalty.
Okay. I was just curious.
Okay. Thank you.
All right. Any questions from the board? Any discussion? Then I'll entertain a motion on number 66. Can't hear you, Jeanette.
I make a motion, we uphold the county's value appeal.
I have a second?
Second.
All those in favor, aye.
Aye.
All opposed. Okay, I guess we need to take another break until 12 o'clock. Is anybody here from the Van Allen office? Okay, let's take a break till 12.
I think so.
All right, it's 12 o'clock and looks like everybody's back. So Mr. Carl, are you here for one of the Van Allen properties?
I'm sorry, sir. No, I'm here for J.J. Henderson.
Jay Henderson. Okay. All right. Well, we'll get to you here in a little bit. Is anybody here from the Van Allen properties?
The Van Allen attorney is trying to connect to the meeting.
Okay.
Right. I was going to just tell you that Mr. Mercer is trying to join in. He was having technical difficulties.
Okay. Hello, Ms. Schultz. Which property are you here for?
I'm here for J.J. Henderson. I work with Brian Carl.
Okay. All right. Well, we're waiting on the people before you, but if it doesn't come soon, we may skip ahead. So.
All right. We'll hope for that.
There to talk to them.
There we go. Good.
Mr. Mercer, how are you?
Well, good afternoon. How are you, Mr. Chairman?
I'll be hanging out so you can join me.
Okay. All right. Well, let's go ahead and get started. Ms. Allen, let's get you sworn in first, please. You need to unmute yourself. Do you swear or affirm? Yeah. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name and position with the county, please.
I am Kenya Allen, commercial appraiser with Durham County Tax Administration.
All right. And this Van Allen office, actually, Mr. Mercer, are these two unrelated people, or are you representing both of these properties?
Mr. Chairman, yes, I'm representing both properties.
Should we hear, you want us to hear these together or separately?
You know, we can do one and then the other, do them together. I trust Kenya's judgment on that. We've talked about it. I've submitted an outline. I sent it to the Board of E&R about a month ago before when we were scheduled to have a June 2 hearing. I also sent it to Kenya Allen. We've discussed it. I think we're on the same page on this case. And it's the exact same issue. And our ask is the exact same in each case. So I guess you could take one, we could do it, and then the other, but there's no reason to really call them separately. And which whatever is efficient for you all. Okay,
Ms. Allen, what's your preference?
Like Mr. Mercer has presented, they are the same issue for two different parcels. Presenting both for the same issue is fine by me.
Okay. All right, well then let's proceed, please.
Do you want to hear from Mr. Mercer?
No, I want to hear from you first, Ms. Allen. It usually works better. You can kind of set the tone for us.
So before you, you have Van Allen Apartments, which is two different apartment buildings, and 555 Mangum, which is a 10-story office building and separate parking garage. The attorney representative here today and I have discussed value, and he's told me earlier that he will accept our values. Today, they're looking for release of the penalties from 2019, 2020, and 2021. I'm not opposed to that, releasing those penalties for 2019, 2020, and 2021 as a result of these valuations.
And so why is that? Why is the penalty being? Why are you in favor of relieving the penalties?
Because the taxpayers cooperated with the tax office in a timely manner, and we were able to discuss value and resolve that back to 2019 forward.
Okay. All right, Mr. Mercer, I'm going to need to get you sworn in. I know you're a lawyer, but since you'll probably be presenting some evidence, I feel more comfortable swearing you in.
Yeah, that's fine.
Okay. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. What do you have for us?
And let me say, first of all, that I've enjoyed working with King Allen. I worked with her on stuff before. We did not agree on the values of this property, but despite that, we get along very well. She's very professional. And we've actually had a good time doing this case, and we've had a lot of conversations to get where we are today. On each of these properties, both 555 and 511, we have given our values to her, and we have a disagreement on value. But let me just say where we are and why we think a release of penalty is appropriate. On 555, as I said, we gave the county tax office our estimate of value. Kenya Allen worked up her estimate of value and gave it to us for 2019, 2020, 2021. We think that there's an error in the process, which I don't really think we need to get into, but I could. Durham County originally did not have this building properly reflected in its property tax records, as it only had the parking garage on its listing. And then it discovered the building in its review process and pulling information from building permits, all information which the taxpayer had given. So there was no way for the taxpayer to know that Durham County didn't have the assessed value on the building. We didn't know that. And so there was no failure to list by the taxpayer. We're in agreement with that. No failure to list. We're in agreement that the taxpayer did nothing wrong regarding the tax process. And thirdly, as Kenya Allen said, the taxpayer fully cooperated with the county, which included the taxpayers providing all requested information and discussing the valuation with Ms. Allen. And that's why the county has agreed they have no objection to the penalty being waived. So at the end of the day, our position is that we will accept Durham County's values, which are quite higher than the values that we've presented to the county, quite higher. But the taxpayer frankly wants to resolve this and move forward. And they have authorized me to say that we will agree with the values of the county and agree with this process if the county, the Board of E&R, will forgive the penalties for each of the years in question, 2019, 2020, and 2021.
Okay. And Ms. Allen, you're in agreement with all that, correct?
I am.
Okay. Any questions from the board? Any further discussion? And then I'll entertain a motion regarding items 67 and 68.
I move that we uphold the county position and forgive penalties for year 2019, 20, and 21.
Do I have a second?
Second.
All in favor say aye.
Aye.
All opposed? Okay. All right. Thank you, Mr. Mercer.
Thank you, Mr. Chairman. Thank you, members of the board. And thank you, Kenya Allen. It's been good working with you. We'll be working in the future. And thank you for your professionalism and being available, including helping me get on the Zoom call today when I thought I didn't have the right Zoom.
I am here for you, Charlie.
Y'all have a great day. Have a great week. Thank you very much.
Okay. Thank you.
See you later.
All right. Well, we're a little early. And I don't know, Mr. Carl, are all your people here? Are you ready to proceed? I don't know who else is with you that you might need.
Yes, sir. Catherine Schultz, my associate, and our legal representation, Stephen Carr, are all present. So I think we're happy to proceed.
Okay. All right. Well, the first thing I want to do is get the three of you sworn in. So let's do that. If you'll raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Yes.
And you are comfortable using this video format?
Yes, sir.
Yes.
And Mr. Carr, you're an attorney, is that correct, representing them?
No, I'm sorry, sir. That's not correct. Stephen Carr, who's also on the call, is our attorney. I'm a representative of the owner.
Right, yeah, Mr. Okay, so you're representing, and so are you employed by the company or what's your position?
I am. I'm a VP of Asset Management for our LIHTC tax credit properties at California Commercial Investments, who are the property managers, and also we represent part of the ownership group as well.
Okay, and Ms. Schultz, what's your position with this?
I am Mr. Carl's associate in tax credit asset management.
Okay. All right, well, we will start with the county. So Ms. Allen, you know, she was sworn in previously. What's the deal here? What's going on?
J.J. Henderson Senior Living is requesting a 2021 untimely appeal based on the fact that they were not properly notified by our office. We are required to submit a change of value notice, and which gives every owner an opportunity to appeal or have their value reviewed. And these owners were not given that opportunity. The change of value notice letter they were sent did not include a street name or street address. It included the business name and a suite number and a city. So and it was mailed May 31st of 2021. So they would have had 60 days from May 31st of 2021 to appeal, but the letter could not be received by them because it doesn't have the street name on it.
Okay.
Got it. Looks good.
So it was an error made by the county, and that's why it was delayed, why it was late. Okay. All right. Well, we'll hear from the owners, but it sounds like it's a pretty straightforward case.
Okay, thank you, Mr. Smith. I appreciate it. And I will try not to talk too much since it seems so straightforward. Essentially, we took over ownership of the property in December of 2020. It had previously been owned by the Durham Housing Authority and was tax exempt under their ownership. Also, Durham Housing is also a partner in the current ownership with the group that I represent. This is a tax credit LIHTC rehabilitation, senior living, Section 8 subsidy housing. So it was our intention. So during 2021, we had retained Mr. Carr to help us with the tax appeal. We wanted to make sure we kept the tax exempt status that it had enjoyed in 2020. So in 2021, we were working with Mr. Carr for the tax exemption, continuity. And during that time, we did not know whether we were still exempt in 2021 because we had not received any notice of such. So we went forward with filing an appeal for 2022, and essentially during that time, we were notified that, or it came up on title in January of 2022 that we had an outstanding tax bill due. And if I may rewind, when we were in 2021, when we were working with Mr. Carr for the tax exemption, we in good faith, we looked online to see if we did in fact owe any tax for the 2021 year, and there was nothing there. It was zeros across the board for the parcel we had entered. And secondly, we had never received any notice to our offices. So based on those two things, I think we assumed that 2021 was also tax exempt. So we did not move forward with filing the tax exemption request. We did move ahead with the 2022 exemption request, which was granted by the board, but that was put forward in January 2022. So as soon as we learned that we had a tax bill, in good faith, we paid the 2021 amounts and we immediately filed the tax exemption. I believe it was in January 24 of 2022. So I think we missed the cutoff by about 24 days or so. And the main reason was because, as stated, we had never received notice during the 2021 year. Had we received that, we would have moved to get the appeal in, or the exemption appeal in timely in 2021.
So did you pay the taxes for 2021, you said?
Yes, sir.
So will
we
you
have
refunded to you if we pass this, Ms. Allen? Or how does that work?
We would ask for a refund. Yes, Your Honor. Yes.
All right. Okay. Well, I think we understand. Any questions from the board? Any discussion?
Just to clarify, if I could, Mr. Chairman, Ryan talked about we filed an appeal in 2022. It's actually our application where we also disclosed that we had not listed and we had not received a notice of listing from Durham County in 2021. And that's when we discovered, in fact, he got a title update from his lender and found out we had a tax bill. And then we called the tax office, and that's when, as Ms. Allen pointed out, we got a copy of the bill that Ms. Markle said had been sent to us, but we didn't have a copy of that until, without the street address on it, until March 1st of 2021. That's the first time March 1st of 2022. That's the first time we'd actually seen it. So we had some evidence that there was some effort on the part of Durham County to do that, but we filed for the application. The application for exemption in 2022 was granted, but that's when the county also said that you were too late for 2021. And so, but the reason we were late is because we never got a notice of a bill. We never got a notice of a listing from the county, as Ms. Allen pointed out. So that's the reason we're here today. We think the facts haven't changed. This property was exempt in 2020 before we acquired it. It has been always operated as a low and moderate income housing property, and should have been exempt in 2021, and certainly is now exempt in 2022. But so yeah, for purposes of the relief that we're asking basically the county to grant us the exemption for 2021 and to give us a refund of the taxes that we've paid.
Okay. All right, Ms. Allen, you have some comment?
And my comment is only to say that I am speaking to the 2021 valuation, not anything pertaining to exemptions.
Correct.
Only value for an untimely 2021 value appeal is my presentation's focus.
Okay, well, yours is the value, not an exemption. Yours is a value appeal.
Well, we've asked for both things, actually. If the exemption were not granted, which we believe it should have been granted, because clearly the county determined that we were eligible in 2022. The only issue that we understood was the basis for the denial was that we were late. And so, and our point is, no, we weren't late because the county didn't give us notice. There was a valuation at $15 million and more. We believe, in fact, the county, when we pushed back on that, once we found out that was the tax bill, we said that's way too high. This should, if there's a valuation for a low-income housing tax credit property, it should be valued at much less. And so they asked us for income and expense information for 2020. We provided that information, and our proposed valuation was somewhere in the neighborhood of $1.8 million. But 15 million was just way too high. But our main point is we should have been given an exemption for 2021, and we understood that the only reason we were turned down is because we were late.
Okay, so Ms. Allen, so if this is an appeal. This is only an appeal. So if we grant this, what happens?
If you grant the 2021 appeal, I will review the valuation and value it based on how they were renting it for 2021.
Okay, so
they won't. Don't grant me untimely. I can't review how we came to the value and if it needs to be changed.
Okay, so you won't have anything to do with an exemption.
Correct.
Okay, all right. Oh, yeah, Mr. Carl.
Yeah, Mr. Smith, if I may clarify, I'm sorry if there is some conflagration of these two issues. We were under the assumption that essentially there are two very distinct issues here. One is the exemption application that was denied based on the late filing for the exemption, and I think that's the main point that we are trying to address. Apologies if we misunderstood the notice that we got, because these two issues are kind of tied together. Essentially, from our point of view, the exemption piece is the most important thing to focus on, because we feel that because we, in good faith, searched for it and we didn't receive notice, as evidenced by Ms. Allen, that essentially the late filing of our exemption for 2021 is kind of the focus, which we think should be relooked at or reconsidered. And then essentially it's if that was shot down and we were determined not exempt because we filed late or for whatever the reason, then we would move to essentially the argument that we would like to appeal the value which was assessed, which was like 15 million, and we've proven it out to be closer to 1.5 million or something. But we're essentially hoping that isn't even part of the discussion, because the focus is that we didn't receive notice, and therefore we weren't able to file the exemption request for 2021 timely.
But at this stage, we're not being asked to grant the appeal of the exemption. We're just being asked to the appeal of the value. Is that correct, Ms. Allen?
Correct.
So you would need to file another appeal for the exemption, because this is not the exemption appeal.
Well, Your Honor, that's what we understood we were doing. When we got the notice from the county on February 20, it was dated February 21st. We received it on the 28th. All it said was untimely application. The 2021 request for exemption was received after the end of the calendar year in which taxes were levied. So that's what we understood was the basis for the denial of our exemption application. So I appreciate that somebody has said, well, okay, if you have a complaint about the valuation, then let's take that up too. And so we basically, in the submittal that we made with our submittal of our notice of appeal, we identified both points, both the fact that we were denied the exemption and because it says untimely application. Well, we don't think it was untimely. And so we think the matter before you is both the matter of our application for exemption and we're appealing that denial. And if that is not granted to us, if we are not granted an exemption, then we do want to talk about the tax value. But to Mr. Carl's point, we don't think really need to talk about valuation, because your own notice of the denial of the exemption was it was because we were supposedly untimely. So we think that issue is before you.
Okay, well, let's talk to staff. I mean, what's happened here? Is this an appeal for an exemption?
Yes.
Is it a separate one, or what's going on here?
Kenya, you only have the portion for the valuation appeal. Does Amanda have an exemption appeal available?
But we do not have it ready for the board. I have not brought it to the board yet.
Okay.
Okay. All right. So that's a separate issue.
Right. So yeah, well, the only thing we are charged with right now is the valuation. So it sounds like the exemption is in the works. So we need to stick with just what is on our agenda.
So will that be scheduled later then, Mr. Beatty? Ms. Markle?
Yes.
Yes.
Okay. So we have an opportunity to come talk, because like I say, the notice that I'm looking at, the notice of the denial that we received from your office said was a denial of the exemption. And so that's the reason we thought we were here today, was to talk about the denial of the exemption. And it's the same set of facts. We didn't get a notice from the county. We didn't get a copy of the bill until we heard from Ms. Markle earlier this year.
Okay, well, let's move forward with this, and I guess we'll have to have you back again. I'm sorry for the confusion.
Okay.
All right. Any questions from the board? Any discussion? I will entertain a motion on number 69. Somebody speak up. Jeanette, you're muted, Jeanette.
I make a motion, we accept.
And it's timely.
Yes.
Okay, do I have a second?
Second.
All those in favor say aye.
Aye.
Okay, thank you all for coming, and I guess we'll see you in a month or two.
Okay.
Mr. Is there anything that we need to do proactively to get this set up at this point? I just want to make sure that we're not missing anything.
Ms. Markle, are they okay with it's in the works?
Yep, it's in the works. It'll be in one of the upcoming hearings.
Okay. All right.
We thank you very much for your attention.
Okay, thank you all for coming.
Thank you.
Thank you.
Okay. All right. Anybody have anything else, Starling? I think we already talked with you about the next meeting.
Yeah, that would be it for us.
No, nothing else?
Nope. Any questions from you all to us?
No, no. A little earlier notification though, I think would be good because my mind's not what it was. So
okay, all right. We will work towards having an agenda out to you all 5 working days in advance, and then we will adjust that agenda based on how things get right at the end put in. That can fit. So yeah. We will work towards January. That won't work. July 20th. So by July 14th, that's 5 working days. We should have that to you all Thursday.
Right.
The initial agenda.
Okay. All right. And Ms. Frisbee, welcome. Good job. And we'll see you all soon.
Thanks.
Bye.
Bye.